the movement. This is Jen, and today I want to talk about the positive law citation. And I just wanted to show you some more information that I've gathered on positive law or positive contracts to help you understand why is it that you're being brought in under a system of government that is not federal, it's corporate. And I want to show you just a few things to help you understand the entire situation that we're in. Before I get started, I just wanted to mention that whatever you do, whatever you can do, whatever you're able to do, even that if that is only learning, then that's enough. Whatever you can do is enough, even if you're just listening to the videos and thinking about the things that are being said, whether you're listening to my videos or anyone else's. Or maybe you're just trying to get involved in buying commodities through the stock market. If that's all that you can do, or maybe collect gold and silver coins, then that's enough also. Whatever you feel like you can do, and it's within your comfort zone, then that's what you should do. If you don't want to get out of your comfort zone and you can't do some of the things that other people are doing, then that's okay too. Don't let anybody stop you. Don't let anybody tell you you're not doing enough, you're not doing the right things, that you got to do this, that, or something else. Something that I've discovered, I guess, in the last 10 years or so is that you have to do what's right for you. You can't do what other people want you to do, because then you're just pleasing other people. And sometimes you get yourself in a situation that you're uncomfortable in and you can't or don't know how to get yourself out of. And I would want to avoid that. So what I do is I just teach the things that I see and what I think I know. I'm putting two and two together, and I'm trying to help other people see what I see. Okay, so this is a non-combative channel. I support whatever anybody does. If I think that they're wrong about something that they're teaching, then I just simply go and reteach what I feel is right. So welcome to my channel. If this is the first time you've been here, if you've been around for a while, welcome back. Please consider liking, sharing, and subscribing. So here we're on the uscode.house.gov website. This does not appear to be an official government website, even though it is a .gov website, because they're starting to put up here in the left corner, official U.S. government website, where this one does not have one. This is the Office of the Law Revision Council, United States Code. And if you want to go over here and read all about the positive law citations, you can click off to the left and you can read it. I've read this long explanation of positive law citation, and to me, it's just confusing. But you can go and read that if you want. It's there. And at the least, you'll gain some extra information. I try to keep it simple, stupid for myself and for anybody else, because learning something for the first time can sometimes be difficult. Once you get the hang of it, you start to understand it, you can move along rather quickly, but it's the initial learning that sometimes is hard. So at the bottom of this page, which I can't seem to scroll up high enough to show you, it says that the asterisks next to the titles means that the law's been made positive. I've done a lot of videos on this, so if you want something more explanatory, you can go into one of those other videos that I have made and learn what the positive law is in more detail. Here I'm going to go over it quickly. So we go to Title I and we can click on Front Matter. And when we click on Front Matter, a window pops up and we see that Title I, U.S. Code Front Matter, has a positive law citation. It's right here. Positive laws just simply means that the title and the laws within it have been made positive, meaning that they've been properly enacted into law. There's a variety of things that have to be done before something that the government writes can actually be called into law or called law. So when something has been made law, such as a title, it'll be cited in a very specific way. If something has not been made law, it'll be titled, it'll be called some other kind of thing, some other kind of way. But when a title has been made a law, it's cited specifically in such a way that when you see it written that way, you can see that it's an actual law. It's been actually passed into law. So Title I is cited as, and you can see here, it's been made positive. It's been enacted into positive law and cited as 1 U.S. Code section, and then you just add whatever section you're citing. For example, Title 26 has never been passed into law, so it may be cited in some other kind of way besides 26 U.S.C. section. And they can get kind of detailed in their variety of ways of citing it. So on the W-4 form, I believe they cite it as Internal Revenue Code section such and such. But that's not how you cite a law that's been enacted into law, or a title that's been enacted into law. Even if they say Title 26 Internal Revenue Code section such and such, it's not been enacted into law. The citation is your first prima facie evidence. That means on its face, at first glance evidence that you can see right away to know that something's been passed into law by the citation, the way it's cited. Now, if you go to 1 U.S.C. section 204A, you can read this section here. You can read it later on your own. But what it says basically is that citing it in a certain way shows that the evidence that the title's been made positive, and it's a positive law. And as a positive law, it's been made a law. It shows that it's been properly gone through all the channels before it can be called a law. So here we have Title 2, Title 6, 7, 8, 12, 15, 16, 19, and so on, including the Internal Revenue Code, that have never been passed into law, and they have no title. They have no positive law citation. So if we go to Title 26, Internal Revenue Code, and we go to front matter, you see there's no, you see that there's no positive law. And you can go through here yourself and look for the positive law. It hasn't been made positive. It's not going to be made positive until you sign the W-4. And once you sign the W-4, you look down into this comment section, or the section that shows the source, and the source is something like 26 Internal Revenue Code such and such, but that's not the way you cite a law. So it doesn't become law until after you sign the paperwork saying that you promise to donate a portion of your income to the corporate side of government. So if we look, we see that Title 12, Banks and Banking, has never been passed into law. Commerce and Trade has never been passed into law. Conservation has not. And you can go down the list on your own. I've given you the website. So let's move on to some different things we can look at to learn what positive law is. Positive is also used in the phrase positive contracts. Contracts are things such as treaties, accords, alliances, an arrangement, a concord, a bond, and many other things. So to be made positive, it just means that it's affirmed, that it's been done, that it's expressed or implied, which are types of contracts. It's inarguable, it's incontrovertible, indisputable, and these are just synonyms for positive law. For positive, the word positive. So when you talk about positive contracts, you're talking about an affirmative contract, an affirmative agreement, an explicit agreement, an explicit contract. These are words that are important to understand when we're looking at the definitions of these words and phrases. Now, when I go to the definition of a word, I like to look at the etymology of the word because I like to see what it means throughout time and to different languages. And sometimes the spellings can change a little bit depending on what language the word came from, as well as what era it was used in. So the definition can change a little bit from one language to another and from one spelling to another. So we need to keep those things in mind. For example, I use the word defense, which is spelled with a C in the Constitution, but everywhere else it's spelled with an S, and the Latins spelled defense with an S to mean vengeance, and the Norse, which came to be known as Old French later on, used defense with the C to be spelled as fortifications. And fortifications is used in the Law of Nations. So defense with the C is in the Law of Nations, and it's in the Constitution. So I'll try to give my sources for all of the books that I show you today. And we're going to start, I guess, with this one. These are not really in any particular order. I have a whole bunch of them up here. The Science of Jurisprudence, a treatise in which the growth of positive law is unfolded by the historical method and its elements classified and defined by the analytical. This is by Hannes Taylor and was copyrighted in 1908. So I've sectioned off a couple parts of this book, but it has a lot to do with positive law, has a lot of information on positive law. And we'll have to scroll through here. But positive law is used in contracts, and once you agree and you sign, it's said to be made positive. So when they write titles and they're not passed into positive law, they're basically offers to contract to which the various entities have to follow when they're contracting with people. So if a government instrumentality is going to contract with someone who's not a part of government, they have to follow those non-positive titles, and they have to offer you the forms, the federal forms. So you're thinking that this is an order by the federal government or something that you have to do because you believe it's in the Constitution and that's your duty to do it. But nobody outside of the Constitution, no one off federal lands, aside from the states and some purposes, for some purposes, have to do anything that's in the Constitution, because the Constitution wasn't written to govern the private people of the states. It was written to govern the states and the military and the people at the seat of government and their employees. So there's different philosophies on what positive law actually is and what it isn't. Its origins are from the Roman Empire. And so we would want to sort of go back there to see what its origin was, but we can pick up changes which occurred through time based on what a variety of attorneys and judges and philosophers have written, because law is a science, and it's a science that involves philosophy, and it involves truths and principles and trying to find truth and trying to find the right and best way of doing things, the most convenient and fair way of doing things. So we have to keep those things in mind when we're reading the various things that people say they believe something is, because remember, philosophy is a belief until it's proven, and there's actually very little in this entire universe that can be factually proven with demonstrable evidence. Okay, and a video I did recently, one author says that the only thing that can be demonstrably proven are mathematical equations. It's very hard to prove a mathematical equation in court. So what they do is they use fictions. And these fictions are to move people, to get them to believe something so that they'll just go along with it. Recently, in an interview with Lynette Zhang, a man who was interviewing, I forget his name, I don't even remember his channel right now, but I posted a small clip of it just before this video. And she was saying that they can't tell you why or how they're doing what they're doing because it would bring an end to it all. So there is an end to it all. And I believe that knowing is actually more than half the battle, because once a majority of people have an understanding and they know something is wrong, or they know it's BS, or they know it's a lie, they won't go along with it anymore. And how do you look at a group of people in the face and lie to them when they know that you're lying to them? So in the old days, they would probably throw tomatoes and potatoes and things like that at the speaker and boo him off stage. And so they would have no force, they would have no power or authority, because basically right now the only power that they have over you is your ability not to understand what they're saying, because they're not giving you the information to understand it, because if they did, it would bring their entire system down. And that's what Lynette is saying. And what I'm trying to explain to people is that everything that they're doing is just a contract that you have to sign it. And once you sign it, you make it by your signature positive law, and it's positive law for you. So if I don't pay taxes, you're not paying my taxes. Maybe in some sort of roundabout down the road way you are, but you are not specifically paying my taxes. Okay, so you're not responsible for me. But if I sign a contract saying, like the W-4, saying that I'm going to pay a certain amount of money in taxes based on whatever I earn, I'm going to be expected to pay that because it's a contract. And when I signed it into law for me. Okay. The problem with some of this stuff is that once something happens for a long period of time, it starts to become a custom, and it comes under the custom laws. And custom laws can then be made actual laws. And it's very difficult to stop a custom that has started and been going on for 100 years or more. So it's already been since the 30s that this system of taxation through contract has been going on, and it needs to stop. Otherwise, by 2030, which is 100 years, if you go back to 1930, I guess really it was 1933, then it would be considered a custom, and they wouldn't need you to sign a contract. So back to the philosophies. Austin had his own philosophies about what positive law is and what it isn't. I've read a couple of his books on positive law, and I just can't get there. And I think it's because he's writing from the perception of church is state, and God and government go hand in hand. Whereas in America, we don't have that. We have separation of church and state. That doesn't mean that God does not exist and that he can't be a part of our lives while having government separate. It just means that when I read Austin's stuff, I have to read it with a grain of salt because he's got a different perspective. Now, I don't know how the laws in England were back then. Perhaps if he were to write something that promoted the separation of church and state, maybe it wouldn't, maybe he would have gotten in trouble or something. Because way back in the early times, such as I think it was Galileo Galilei, he got in trouble for saying that the earth revolved around the sun instead of the earth being the center of the universe. So that may have been the case for Austin, I don't know, but he writes really from a perspective of church and state together, whereas here we have them separate. So we take what he says with a grain of salt. He says the essence of Austin's quaint and pedantic description of positive law is that it must be a command armed with a definite sanction and issuing from a determinate authority. Every positive law is, quote, set by a sovereign person or sovereign body of persons to a member or members of the independent political society wherein that person or body is sovereign or superior. So I'm going to explain something here, and this is something that I think a lot of people have a hard time with just because it's not something that's mainstream. If you go back to the very early days of the creation of the Constitution and everything that was going on during that time, you have a totally different feel for what the Constitution was and what the people wanted and what was going on. And that feel was that the federal government wanted to have some control over, or the states in general wanted to have some control over what happened at the higher level. So when they created the Articles of Confederation, it was difficult to get people to show up from the states. And so when they created the Constitution, they created a system that had a little bit more force that could get the people to show up. Well, how do you do that? You give them a commission and you tell them they have to. Okay, and these commissions were officers. So the way I explain this is that when they put George Washington into the seat of presidency, they did it because he was the best qualified and he had a commission. As a matter of fact, I believe he had two commissions, one after the other, as the general leading the Revolutionary War, right? And so he had that commission, and so then he was seated as president. Well, in the Constitution, the president has to have 14 years being a citizen of the United States. However, the United States wasn't created yet. They were in the process of creating it. And the president had to have 14 years citizenship. So he had to have 14 years in service to the United States. And how do you become in service to the United States? You have to become a capital C citizen of the United States, which makes you basically an officer on federal lands in the military. So a military officer serving his country for 7, 9, or 14 years could then qualify to go to the seat of government because he had been in service to it for all those years. Okay, so it also says, as part of the qualifications, that they cannot be also an inhabitant of the state where they were elected. So the federal lands for military posts are inside the state. Okay, so they're inside the state. They're not inhabitants of the state when they're a military officer. They're only inhabitant or resident of the federal lands inside the state as officers. So if you go to any military post, you will see you'll see the fence with the barbed wire pointing out, because the state people are not allowed inside the federal lands because according to Article 1, Section 8, Clause 17, the federal government has exclusive authority, meaning it keeps the state out of its federal lands so that it can do what it needs to do for its military purposes. This is important to know because the president is the commander-in-chief of the United States Land and Naval Forces, but he's the executive, meaning he's second in command of the states, the United States of America. Okay, so when we say states, individually, we're talking about United States of America. When we talk about states in their collective capacity as a military force, as representatives, we're talking about the United States, and the United States are the seat of government and the federal lands used for forts. And those are the only places that the United States are supposed to have. Places purchased for forts and the seat of government. So if that's the case, the president is to commission all the officers, and the officers, after having served so many years without a break in service, meaning not a resident of the state or an inhabitant of the state, so you can't be in the military, go become an inhabitant of the state, and then get elected. You have to have you have to be in service, working for the federal government as a federal officer before you can go to the seat of government. Because if you're not in the military, you have to be an inhabitant of a state. Okay, so if you're an inhabitant of the state, you cannot be an inhabitant of the state when you were elected. Lincoln changed all that, and he did it outside of the Constitution, so he had to act outside of his oath to do that. And when I say Lincoln did it, I mean his entire administration, including the vice president who became president once he was murdered. So those people are the ones that are supposed to go to that place. So the reason why this is important is because when we're talking about the laws in the Constitution, we're talking about certain people in a military capacity representing the states individually and collectively for certain specific purposes, and those purposes are listed in the Constitution. The president, as commander-in-chief, can order and move them around and have them go to different places to do certain things that benefit America, the states individually. Okay, this is just the way I understand things. So when Austin's talking about how he can command, the sovereign commands, he's talking about the legislature, which was given power to write laws for the United States, which is the seat and the lands purchased for forts, the military basically, and the civil servants. Civil servants is a whole nother thing. The military cannot order civil servants. Okay, that's like ancient law. The military has no authority over civil servants. So they hire civil servants to sort of help the military with some of their administrative functions and the things that they are outside of military duty, but they need help doing them to get the military duty done. So the president can order them, and the legislators, the Congress, can make rules and regulations for the places purchased. And the states can't interfere with that. Okay, that's the exclusive legislative authority over the seat in Article 1, Section 8, Clause 17. And the next portion of that sentence is that the like authority is at the places purchased for forts. So when Austin is talking about positive law, when you apply it to the American system and our Constitution, the laws that are positive are the ones that are in the Constitution that the federal government has a right to make for those certain people on the federal lands. So, example, Title I General Provisions is for the seat of government and the places purchased. Okay, this is what they're saying. This is how we're going to carry out the things listed in the Constitution. Now, Title II is not a positive law, so apparently they're not carrying out those things in Title II according to the Constitution. These are like contractual things. Title III, IV, and V are all passed into positive law. And so the Congress and the president can make orders, rules, and regulations according to the Constitution for those people on the federal lands. So if we look at Title V, we can see that it's for government organization and employees. Now, if we go to Title X, we're talking about the armed forces. And we know that the commander-in-chief, president as commander-in-chief, can order the armed forces, and the Congress can make rules and regulations. Now, if you go to congress.gov, on almost every single law they pass, they'll tell you what the constitutional authority is for passing that law. And 9 times out of 10, it's going to say Article 1, Section 8. Well, Article 1, Section 8 is just one sentence long, so I'd like to point that out. And so it all comes together. You can't take it apart and say, well, you know, we can make Article 1, Section 8, Clause 1 taxes for the entire country, when later on it tells you that they have the authority to make laws for the seat of government and the places purchased for forts, because it all goes together. It's one sentence. The entire Constitution goes together. The only part of the Constitution that benefits directly the states in their individual and collective capacity are the things listed that shows what they're going to do, how what they do affects us. So it's to promote defense, general welfare, etc. Okay, so they can't order people off the federal lands. And remember the fence, and then you have the barbed wire. Here's the state over here, and inside the fence is the federal government. Okay, so if they put a fence around Washington, D.C., that's fine with me, because I don't want to go in there anyway. Okay, we have a right to be there. It's really state land for state people, but that's where they are set to do their work. And it doesn't need to be as big as it is, and it doesn't need all these buildings and all these employees and stuff. If you look into some of these titles and you start really looking at them, you'll see that the only people who are required to pay an income tax are the people who work directly for the federal government and receive benefits from the federal government. That means health insurance is a requirement for federal officers and employees. Direct deposit is for federal officers and employees, or veterans who are receiving a monthly check for a disability or a school or whatever they're getting their checks for, and also Social Security recipients. So they would also receive a check, direct deposit. Now, if you work off federal lands, you're not required to have direct deposit. The problem is that private businesses are registering their businesses with the federal government because they either believe they have to, or they're getting some sort of kickback or what have you. They think that they're going to pay less in taxes, but this is not actually the case. This is not really what happens. You register with it, and that's a contract. So you're registering under one of these non-positive law or non-positive titles not made laws, which are contracts, and you're registering with the instrumentalities or the tool of the federal government, because from a constitutional perspective, they can't come off the federal lands and do anything. All that they can do is only on the federal lands with the federal officers and the employees. And we know, especially now more than when it was first written, there are a lot of dependents, wives and children of these military people who live in, and some work on post also. And then we add in the contractors who may also receive um, money directly from the government, to which has to be directly deposited. Now, the fence with the barbed wire, we're on the state side. That means we're private people. We're not a part of the federal government. We're private. And when Washington left office, he was writing to a friend of his, and he said he was going to retire from public service or service to the public and become a private citizen and live a quiet life on the Potomac River. This is similar to the wording that Trump's attorneys used in an article where his attorneys said Trump has returned to the life of a private citizen, something to that effect. Okay, so you have to understand public is them, they're in the public eye, they're in the collective eye, and so we're all supposed to be looking at them and scrutinizing them and seeing what they're doing and making sure that they're not screwing up. So when the federal government says that the private people are rising up against them, there should be no reason for us to rise up against them because they're supposed to be on the federal lands. So if we rise up against them, if we have to rise up against them, something really wrong is going on, and something really truly is wrong. And it's the fact that they've been using these corporations as instrumentalities to contract with people to make billions of dollars off of, different things that they're giving us, and creating issues that would probably never have been had they not got involved. They're making billions of dollars, and it's all because we're contracting with them either expressly, meaning in writing, or I think it's implicitly, by way of our actions. Explicit. Okay, and we do it individually until it becomes custom after 100 years. So when the federal government is issuing a command, it's issuing a command to the people who are in a variety of statuses. So they may be receiving a check directly from the federal government as a compensation for service, like a contractor. They may be working on federal land. So a civil servant, meaning a civilian or a private person who comes onto the federal lands to do work, but not in a military capacity. And then you have the military. Okay, so when the president issues an order, he can really only issue for the military. Okay, he can do some other sort of executive document to order the states, but only for the purposes that are in the Constitution. And there's not that many of them. There's not many things that the president can do or order a state to do. And when I was in the military, executive meant second in command. So I'm not even sure that he can really order the states to do something. It would be the states that are supposed to order the president. I think that was put in there because in the event of a war, if the governor and his mansion and the capital got wiped out, it wouldn't be the end of the state because they would also have to take out the president. And then you have the president, and then you have the vice president, and then you have the Speaker of the House and all these other people that you really have to take out of the picture before you can overtake a country and take its flag. So there's thing after thing after thing that would have to be done. And that's a good thing. So I'm not necessarily knocking the Constitution or the military or the way government has set up. I'm knocking down the corporations and the contracts that they've made with people outside of the Constitution, all the while pretending that it was all constitutional all along and according to law, which is a lie. So it says every positive law is set by a sovereign person. That's the Constitution. So the Constitution was set by sovereign people. And so the Constitution is there and it's real and it's in effect. And maybe it's good, maybe it's bad, maybe we need a few more things done to it or a better understanding of it. But those are the things that are made positive, those positive law titles, okay? Those are the constitutional things. And they can command those people, and those people are on the federal lands and work for the federal government. So how do they get around that with the corporations? What they're doing is they're taking these instrumentalities, they're pretending that they have an authority that they don't have. They're allowing them to use federal forms, and that makes people that they're trying to get to sign the federal forms believe that they have to do it because it's a quote unquote federal law. And we all believe that the federal government has this huge authority that it doesn't actually have. It doesn't have jurisdiction over private people. Okay, so in Austin's philosophy of positive law, he says the word command is the key to his analysis of law. It's who can command who. So the people are supposed to command the state is supposed to command the federal government is supposed to command the military, who are the representatives who go and do certain things. I think there's also ambassadors and ministers who may not be military. We also have civil servants. And it appears to me, looking at some of the old laws before all of the judicial opinions that may or may not have been infiltrated by corporations already by the 1850s. We know for sure by the Civil War, before the Civil War, the corporations had already infiltrated government. And we know from Rockefeller Medicine Men, they talk about how Rockefeller had basically bought Congress. So all he had to do was buy them enough to get them to create these instrumentalities. And the 1871, what they call the Organic Act, also I think was part of the thing that allowed them, Congress, to do this. So it's completely outside the Constitution. They can call it contracts, they can call it treaties, they can say they're allowed to do this, that, and the other. But if you look at it from a different perspective, you can see that the people they're supposed to protect, they've turned on, and they've made them us all basically subjects of it to bring in more money. Okay, so let's move on with this document. So I wanted to explain to you, I know it's a long explanation, but I wanted to explain to you the idea of orders and ordering and who can order who. The people order the state orders the feds, and the feds order the military. The military can never order civilians, okay? Only those certain higher ranking military people can order the military. Now, supposedly, when I was a civil servant, I was told that I could give orders to a military person. Okay, we just didn't do that. You just didn't do it. It's not something that was done. So I've never tested that, and I don't know for a fact that it's true, but that's always something that I've heard. Let's see, those conclusions was reached that the true laws, those only are the subjects of jurisprudence, which are laws strictly so called, or positive laws. And then we're going to move down this document. We're just going to look at a few other things. I just want to enlighten you. And I want to enlighten you because it starts bringing light to your thinking. And it starts helping you to understand and see the bigger picture in all of this going on around us and what they're doing. And again, I'd like to refer you back to the short clip that I posted where Lynette Zhang was doing an interview, and she said, they don't want you to know what they're doing, because when you know, then you know it's a scam and you won't do it anymore. Let's look at another document. Okay, this is the Institutes of American Law, Volume 2. This is of things. Okay, so this is number 1501, Book 2, Part 2, Title 5, Chapter 12, Section 6, Sections 1, Article 3. And this is, again, Institutes of American Law, Article 3. It's of things, of the dissolution by an award and judicial proceedings. So this is a positive dissolution. It says 1501, the courts of common law have no jurisdiction to decree a dissolution of a partnership for any cause whatever. I want to bring up just fictions now, okay? There's a lot of things in quote unquote law that are just fictions. They're just fictional. You have a legal system based on real laws, physical laws, the natural laws, and then you have all these man-made things. So this idea that the courts of common law, and the courts are supposed to be made up of just the common people, that they have no jurisdiction to decree a dissolution of a partnership. Now, there may be some logic behind that, but really it's still a fiction. If a corporation is doing something really bad and it's hurting people, it's doing a harm, then it should be dissolved. And the people should have a right to dissolve it. A submission and award may have the effect of dissolving a partnership. When the submission refers by the express terms it contains, express terms that's written down, the question whether a partnership shall or shall not be dissolved, and an award directly awarding the dissolution is made, it will, if it be unimpeached and unimpeachable, ipso facto, amount to a positive dissolution, like in fact dissolved. Okay, so positive is like affirmative. It's in fact. It's affirmed. It's irrefutable. It's been dissolved. Okay, so we're looking at positive. Okay, so here's now in number 1338 of particular contracts, Book 2, Part 2, Title 5, Chapter 10, Section 5, and Section 1 of 5, or subsection that is, this is Institutes of American Law, the same book. Section 5 of the things, or of the rights of the agent, 1338, an agent's rights may be divided into those against his principal and those against third persons. So in this country, officers have to have a commission. Okay, and an agent, it would depend on whether or not he's a military officer or a civil servant. Okay, civil servants, I don't believe civil servants can be officers. I'd never heard of, when I was working for the DoD, any civil servant being called an officer. They have an office, but they're not called an officer. So I think that in this country, if you have a commission, you're an officer and you work on federal lands and you have no authority off the federal lands. Okay. When you come off the federal lands, it's to bring some papers to the state or to travel from one federal area to another. Okay. If you're traveling and you're involved in an accident where someone hits you or attacks you, then there's an issue, right? Then there may be an investigation. And so the federal agents may have to come off the federal lands to perform an investigation and see what happened. And then they would ask the sheriff to bring the person in. They would have to summons them. Okay, so when something occurs off federal lands to an agent, there may be a recourse of action, but the only course of action they would have is, let's say, a civil servant goes onto the federal lands on a military post, commits a crime, and then runs off. Or a military person who's been living on a military post commits a crime and then runs off past the gate, over the fence, however they get out, off the federal lands into the state. Now the federal government has a right to ask the state to bring that person back to stand for their crimes because the crime was committed on the federal lands. Okay, so subsection 1 of the agent's rights against his principal, 1339. 1. An agent is entitled to receive from the principal a just compensation for his services when faithfully performed in execution of a lawful, not legal, but lawful agency, unless such services are entirely gratuitous or the agreement between the parties repels such a claim. This compensation, usually called a commission, is regulated either by particular agreement or by the usage of trade or the presumed intention of the parties. Besides the ordinary commissions, there are sometimes allowed an extraordinary compensation, either by usage or by positive agreement of the parties. Okay, so let's look at their commissions for a second. So an agent of the federal government has a commission, but if he is given extra duties or has what did we call it, hazardous duties, he would be given extra compensation. Okay, so that's what they're talking about, and it's a positive agreement. Agreement is a contract, so it's a contract between a military officer or a civil servant and the government, to where the government issues a commission to that officer. Now, I've never heard of a civil servant having a commission. Maybe they do somewhere in some other part of government outside of DOD, but I have never heard of any civil servant having a commission. Okay? If they have a commission, they cannot come off federal lands. And if they don't have a commission, I'm not sure that they have any authority, because even a civil servant on federal lands, they can't come off federal lands and just boss people around. They have no authority. Okay, so here of particular contracts, Book 2, Part 2, Title 5, Chapter 10, Section 10, Subsection 1, Section 6 of the liability of the agent. So agents have a responsibility. Okay, so officers of the military, when they step outside their duties and do something and they cause a harm, then they're responsible for that, just like anybody is. 1349.1, the agent is bound to obey the instructions of his principal. So this would be the president or the Congress. Okay, they're bound to obey. Now, the orders are supposed to come from the president. Okay, so military orders are supposed to be coming from the president, and the president, he is the principal. Okay, so his orders come from him to the agent. So anything any agent is doing off federal lands, they're supposed to have orders to do it. Even when they move a military person from one post to another post, they have to have orders. And a voluntary violation of them by exceeding his authority by misconduct, by negligence or omission, and by the performance of any act for which the principal sustains a loss, will render the agent liable for the consequences. So anytime the federal government comes off federal lands and they harm someone, they're responsible for that. So if they came off federal lands and told private people that they had to pay taxes, like a federal income tax, they're liable for that. And they would have to repair for damages. So when they get an instrumentality or a corporation outside the Constitution and have them do it, like a middleman, then I guess they're going to claim that they're not liable and that that's not their responsibility, because all along it was a private contract, even though they were using federal forms to do it, to make that contract. So their forms they all go through regulatoryinfo.gov or reginfo.gov, which is a official U.S. government website. And it'll say on there whether or not the form, that particular form, is federalized or not, meaning it complies with the Constitution and the positive laws or not. And they don't. The W-4 does not. So whenever the orders are positive, so they're signed, they're set, they're it's a contract, it's an agreement, the agent agrees. The agent must either refuse to act or he is bound to a strict observance of them. So if the orders are outside the Constitution, the agent is supposed to say, I can't do that. It's an unconstitutional act. So if the president asks the military to attack the private people off federal lands, then that's a violation of the Constitution because they can't do anything off federal lands. If the federal government asks the IRS to come confiscate our property, he can't do that. It's a violation of the Constitution, and people would be injured because of that, and then they would have a suit against the federal government. That's why they have them as instrumentalities, okay, to kind of get around all that. And so they get your signature on the contract, which turns it into positive law for you. And then they come and they take your property because you signed the W-4 and then you said you weren't going to pay, or you're going to keep getting paid by your employer, but you're not going to pay taxes anymore. Then they get upset and then they come after you and they take you to a different form of court. So it still may be a federal court or district court or inferior court, but you're not going to win because you signed the contract. Agents, you'll never see a military person take a private citizen to court for not paying taxes. You'll never see a civil servant take a private person to court. I believe that's why I think most of the IRS agents now are contractors. But as agents, if they are employees of the federal government, they have no commission. So there again, okay, there was nothing in this. This was 1691 Blount. Okay, here's a good one. This is Bouvier's, Bouvier, however you call it, however you pronounce it. Law Dictionary and Concise Encyclopedia of the Law, Volume 1, A through Error. Okay, so this is page 666. I didn't do this. I've noticed a lot of these kinds of weird definitions are on page 66, but something's got to be on page 666, okay? Something's got to be there. You can't have a 667 until you have a 666. And most of this stuff is all just outside the natural law anyway. So I'm going to say this word, contravention. Okay, so I think that's a C. That sounds like an S. So it's contravention in French law. Okay, so the word itself here doesn't really matter. The offense against those who print or cause to be printed without lawful authority. So if you're doing something without lawful authority, you're doing it legally. Okay, we have an entire legal system built by corporations using non-positive laws, non-positive titles. I keep saying non-positive laws, and that's wrong. They're not laws because they're not positive. They're made positive once you sign the W-4 form. Okay, so it has the word here, positive contract, and I've been looking at this phrase for a while, and I'm thinking, before I found this today, I was thinking it's got to be here somewhere because it is a positive contract. It's positive because it's affirmative, and I showed you the synonyms for positive, and this is the way they describe contracts. They say they're affirmative, they're agreements, they're consummated, they're incontestable, inarguable, indisputable, forcible, express, implied, explicit, implicit. They use all these terms when they're talking about contracts, when they're defining contracts. And I'll just read this little portion here, but it doesn't really matter what this definition says. I want you to pick up on this phrase, positive contract. So it says, originally, this right was not enforced at law, but courts of common law in modern times have assumed a jurisdiction to compel contribution among sureties in the absence of any positive contract. So in the absence of something that's actually real. So the Constitution would be a positive law itself. Okay. The contracts you sign with a corporation, whether it be for your mortgage, for your car, for your credit card, if you sign something to pay something called a federal tax, to do business with the IRS, to um, do business with the FDA or the CDC or whatever, you would have had to sign a contract. And it's the same with all licenses, whether it's federal or state, it's the same thing. It's a contract. You have the federal contracting with you, you have the state contracting with you, and that's how they get extra authority and power outside the Constitution to just siphon money right out of your check. And they do it because when you go to apply for a job in these some of these big corporations, they say that you can't work there unless you sign the W-4 form, okay? Unless you agree to pay taxes. And that's because they're registered with the federal government, which there's nothing in the Constitution that requires any business to register with the federal government or the state government. Some people will argue with that comment just now, but I don't really want to get into an argument over federal and state right now. I don't really want to talk about it too much. So this is the 1850 New Law Dictionary, terms of the common and civil law. And I just wanted to go over the definition contract and just some of the words they use in contract to describe contract. Now, the actual definition of contract is to draw together, to bring together. That's the definition, contract. Con is with, okay, to draw or to bring. And then tract is like a tract, like a walkway, a way you walk, a way you go. So to bring together the way you go. So if you're walking with someone, you're walking with the IRS, you're walking with the mortgage company, you're walking with your vehicle loan people, your bank, you're walking with them because you've contracted with them. You've come together. And that's what that means. Now, they can use the word contract figuratively, literally. They could use all these other similar words to describe contract, but the definition of contract is to draw together and to move together, okay? That's what contract means. So agreement, okay, upon sufficient consideration, and then agreement of two or more persons. They call it a compact here of two or more parties, an agreement between two or more persons to do or not to do something, a covenant or agreement between two parties with a lawful consideration or cause. So if contracts are agreements, which they are, then contracts have to have a lawful consideration or cause, not a legal one. So what are they having us pay for? Some people will say, under the old way of thinking, that we're paying for the roads and we're paying for the this and we're paying for the that. And I'm sort of leaning towards, no, I think it's more just theft. And so if someone comes to your house and steals from you, they have to pay for that. That's a crime and they have to pay for that. So if this instrumentality claims to have some authority from the federal government, which the federal government never had to give to them, and the federal government never had authority over private people to give to an instrumentality over people, then what authority did they have to contract with us in the first place? And they're going to say something like, well, even though they work with the federal government, they're private companies, like we've heard over and over and over again. The CDC is an organization. It's a nonprofit organization. A lot of these companies are, the Federal Reserve Bank is a for-profit organization. I guess the bank is a for-profit organization, but it's a business. It's a corporation. If If they're private and they're working with the federal government, then they're going to say they still have the right to contract with people, but that doesn't mean they have a right to do legal contracts or illegal contracts. The contracts have to be lawful, which means they have to comply with the natural law. Okay, so let's move on. A deliberate engagement between competent parties upon a legal consideration to do or to abstain from doing some act, an agreement or covenant, a mutual promise upon lawful, it always says lawful considerations or cause. So it has to be a lawful cause. So what is it that the IRS is having us paid for? That's what I was getting at before. What are we paying for? And is it a lawful cause? Is it lawful if we didn't know or if we were lied to about what we're paying for? Okay, the writing which contains the agreement of parties with the terms and conditions and which serves as proof of the obligation. Okay, a parole contract. Coming together is a consideration. Okay, class of contracts, those by specialty or under seal in which no consideration in fact is required. So there's many different types of contracts. You can go through here and read some of this stuff if you want to know more on your own. Again, this is the 1850 New Law Dictionary, Terms of the Common and Civil Law. Many of these books I have found searching archive.org. And so you can find them on there too. I will try to post links. That doesn't mean I have a link for every book. I could talk about sovereignty here for a second because sovereignty, you have to be sovereign to give orders. There's an issue with them contracting with non-sovereign. We might get to that and maybe not. I'm already at an hour. But Austin's theory of law is that a positive law is an order issued from a sovereign to a subject or an inferior. So that would be, if we were in England, we would be the Queen's subjects, but we're not subjects here. And we're not inferiors to the president. I'm sure that they would love nothing more than for people to believe that, but that's not the case, because all men are created equal. That's one point. And two, the people created the government for themselves. I've passed it. Here we go. So there's a grammar law that we need to look at really quick. And that grammar law is that when you put in front of certain words, it means the negation of any of it. So if you have either, you mean either starting with the E as in either this or this, like you have a choice. When you say neither starting with an N, that means you get no choice. Okay, so none is one with the N in front. So one would be someone and none would be no one. So sovereign power or sovereignty, that power in a state to which none other is superior. In the state, no one is superior. So if there is no superior, who in the state is sovereign? Okay. Now I want to also mention that these dictionaries are very, very accurate. The older you go, the more accurate they are. And here it has lowercase c for chief, lowercase s, lowercase p. Okay, so these are not meant to be taken as organized entities. Okay, a chief or supreme person like the queen. So in general, any chief or any supreme person Also, a piece of money of the value of 20 shillings. Okay, so that's in England. A sovereign power or sovereignty, that power in a state to which none other is superior. So there is no superior to the people. The people gave a little bit of power to the state to do some business for it, to help it move. And in some of the old laws and philosophies, these sovereign powers, which were given to a state or a corporation, were temporary. They weren't intended to last forever. And we saw in Thomas Jefferson's letter that Princeton has the copy of, that they don't let anyone make copies of or quote from, says that in the natural law, Thomas Jefferson says that in the natural law, laws and constitutions and debt should only last for the lifetime of the people alive at that time. And back then it was 19 years. I have read 20 years in other places, but 19 years is fine. All right. Okay. So each generation has a right to claim its own sovereignty and claim its own power. And they have a right to make laws for themselves. And they have a right to, if you want to talk about the man's laws, they have a right to create their own fiction. They have a right to have their own theater instead of one single government being in charge of everyone and creating a theater for us constantly, the same thing, whatever they say throughout time. We're supposed to have our own theater. We're supposed to be in charge of our own lives. And if you read Robert Greene, The Natural Laws, he mentions something about how everyone has their own fiction, their own mask, their own behavior, their own theater. Everyone acts to some extent. And so we all have our own persona, our own theater, our own fictions that we want to act out in life. And to have someone come along and try to govern that, a lot of philosophers would say is wrong, and that it should only last for your generation, your lifetime, and then the younger ones come along and they have a right to create their own theater, their own fictions, their own world for themselves to do what they want to do. And he says that that's part of the natural laws. Thomas Jefferson did. So here's 1891, A Dictionary of Law by Henry C. Black. So this is Black's dictionary. I believe it's the 5th edition. Positive law, laid down, enacted, or prescribed, express or affirmative, direct, absolute, and explicit. So these are all words that you can attribute to a contract once you've signed it. It's a positive contract. It becomes positive law because you've signed it. Positive law, law actually and specifically enacted or adopted by proper authority for the government of an organized jural society. So these corporations have created a type of society, and this society is one that you voluntarily agree to, which really ends up being a form of quote unquote government. Okay, you hear my dog over here. She's curious about something. A law, in the sense in which that term is employed, is jurisprudence, is enforced by a sovereign political authority. So you make the corporation sovereign when you give them that authority, when you sign their contracts. It is thus distinguished not only from all rules, which, like the principles of morality and the so-called laws of honor and of fashion, are enforced by an intermediate authority, but also from all rules enforced by a determinate authority, which is either, on the one hand, superhuman, such as God, or on the other hand, politically subordinate. In order to emphasize this fact that laws, in the strict sense of the term, are thus authoritatively imposed, they are described as positive laws. Okay, so however they impose it, it's described as positive. So positivus juris, a Latin term of positive law, that was a rule. Positivi juris, I do not mean to say an unjust one. Okay, so they're supposed to be just laws. They're supposed to be good laws. They're supposed to be good contracts, and they're supposed to be not immoral. Okay, positive. The the ancient maxims of law also state that a fiction can do no harm. Anything legal, anything man-made is considered a fiction in the eyes of the law, and they can do no harm. So if you're making contracts and in the contract somehow it allows for the contractor to harm the contractee, then it's an illegal and unlawful contract. It's not moral. So one of two opposite positions being affirmed, the other denied. Okay, that doesn't really mean anything to us right now. Okay, so let's look at this one. Number 4, Institutes of American Law of Concurrent Jurisdiction. Okay, so this is Title 4 in the Constitution, I believe. I'm sorry, Article 4. The Comity Clause, Article 4, Section 2. I've read that this is the Comity Clause. Comity means that you're friendly to other jurisdictions, that you try to get along with each other. So comity spans a wide variety of things. So, for example, you have comity of one corporation and another corporation. Let's say you have a railroad whose corporate headquarters is in New York, and it's caused an injury to someone in Kansas as its train was riding through. So you have one jurisdiction in New York and one jurisdiction in Kansas. Comity requires the judge to take both into account. So it says here, the citizens of each state shall be entitled to all privileges and immunities of the citizens of the several states. Okay, so they want you to understand that the citizens of each state have rights and privileges in all the states. So in one state, then in all the states. And that's comity. It's friendliness to different jurisdictions, okay? So if you travel, if you're a military person and you're traveling from one post to another post in a different state, and something happens in between and they cause an injury to someone, then they have the right to sue the federal government, and the state will not try to remove some of those rights. And the federal government won't try to remove some of those rights, so that they have the rights to sue for compensation for their injuries caused by a military person. This also includes overseas. So I think it was during the war with Japan, and Japan had captured some civil servants, so some non-military people working with the military, and those civil servants, after the war was over and they were returned, were giving a compensation for their injuries because they were caught up in a war. So this was a military thing. Wars are military things. And when civilians are caught up in it, they're given compensation. So this is of equity of concurrent jurisdiction, number 3830, Book 5, Part 1, Title 3, Chapter 2, Section 1, Subsection 2, Institutes of American Law, Volume 4. 1. Courts of equity will not rely or relieve a party where he has entered into a positive contract or obligation. This is the phrase that I'm most interested in, the positive contract, because I've told you in other videos that once you sign the forms, you have made the law a law for you. You have made the title a law for you. So when they cite the title as not a law, So they might write on the W-4 form, Internal Revenue Code, section, subsection, blah, 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 whatever. It wasn't a law. They're not citing it as a law. They're citing it as just a title. It's just an offer to contract with you. And once you sign it, you make it a positive contract, and then you are obligated. Okay, so courts of equity, so you can't find relief in a court of equity. Courts of equity will not relieve a party where he has entered into a positive contract or obligation, and he has been prevented from fulfilling it by accident, or he has been in default. So there's a lot of things around laws and contracts. Lots and lots and lots of information you can read on laws and contracts. I mean, it's insane. So here's the law of contract. This is by Brantley, I think. William T. Brantley, 1912, second edition. And he says the circumstances, this is in Offer and Acceptance, page 52. The circumstances which are in conflict with the notion of dissent may be either some positive act, meaning affirmative act. It's like in writing, it can't be contradicted. You did it. It's there. Maybe it's on the record somewhere. So that's a positive act. Affirmative in character, or silence or omission, negative in character. So when Congress passes a law, a rule, or a regulation, it has to be a positive law. It has to go through all the processes of becoming a law before it can be given a positive law citation. Positive fraud, it's fraud that can be proven. It's in writing, it's there. They can't get around it. Now here, Anson, Contracts, 10th edition, page 341. And Pollock says, Contracts 410. It is admitted law that generally, where there is a positive contract to do a thing not in itself unlawful, the contractor must perform it or pay damages for not doing it. Although the consequences of unforeseen accidents, the performance of his contract has become unexpectedly burdensome, or even impossible. So once you sign the contract, the W-4, to pay the taxes, you're obligated to pay. You're obligated to follow all the rules in Title 26. So if you've signed the contract, it becomes positive because it's in writing and it can be shown and proven. Okay, once you sign it, it becomes law. So Title 26 becomes law. There are people who never sign those contracts and they never become law. So I downloaded this, and let's see, let's go to the front page. This is a congressional record I got from GPO. This is from 1947. Now, 1947 is the year that they passed the requirement for positive law citations. This way you can tell the difference between what is a law and what is an offer to contract, supposedly. Congressional Record, Proceeding and Debates of the 80th Congress, First Session, Index, Volumes 93, Part 14, January 3rd to December 19th, 1947. I just want to show you real quick in here. This is the Index, United States Code, H.R. 1565, Enact into Positive Law, Title I, and entitled General Provisions, 5029. Okay, so when they pass something in a positive law, they put one of these things in the index of the Congressional Record. Okay, United States Code, H.R. 1565, Enact into Positive Law, Title I, entitled General Provisions, 5029 and 5030. Now, when they can act portions of it, and they can act an entire title. So they put a bunch of laws that have a similar thing together, and they put it into a compilation. They make it into a compilation. They give it a name, like General Provisions. and then they pass the entire title into law. So that would mean that some of Title 26 has been passed into law. Yes, some of Title 26 have been passed into law. However, they still only apply on the federal lands because the right to taxation is in Article 1, Section 8 of the Constitution, which we know entire Section 8 is one long sentence, and it applies on the federal lands to the federal officers and the federal employees. If it applied to everyone, they wouldn't need you to sign a contract because it was already a law. Okay? They would only need your employer to tell them how much money you made to send the money just the way they do now. They wouldn't need your permission. United States Code enact into positive law Title 18, entitled Crimes and Criminal Procedure 5049. So once they've enacted all the sections, they can enact the title into positive law. Amendments offered to United States Code enact into positive law Title 17, copyrights to amend 5042. And if you've ever filed a case with an inferior court, the tax court, they'll send you, if you're not a federal officer or employee, they'll dismiss your case for lack of jurisdiction, and they'll send you like 30 pages of confusing statements on how they don't have jurisdiction to hear your case. And the reason why they don't have jurisdiction to hear your case is because you're not on federal lands. You're working for a private corporation. Okay, so I just wanted to show you real quick how sections are placed under certain titles, and then once all the sections are passed into law, they're made positive. Still, those positive laws do not apply to anyone off the federal lands. They're still getting their instrumentalities to contract with private citizens, not citizens of the United States, because citizens of the United States are on federal lands. Private citizens are outside the chain link fence and the barbed wire. And those things are, those laws apply to them, whether positive or not positive. If they applied off federal lands, they wouldn't need your signature. Okay. So let's look at, I think that's just about, I'm still researching more on positive law. I'm still looking at contracts and instrumentalities. And it's my belief that the federal government is not collecting taxes from private people working at private companies through the Federal Department of Treasury. They're using an instrumentality, probably the Federal Reserve Bank or private contractors. And so they're using federal forms to make it appear as though they have some sort of authority to do this when they actually don't. And so I'm trying to help people understand and see it in writing. So that concludes my hour-and-a-half video for tonight. And I hope that if you needed this information, that it helped you in some kind of way. In the least, you understand a little bit more about contracts and writing or signing contracts and how federal forms don't really apply to private people. The next question that people would ask me is, well, what do you do about it? And that would require me telling you how to live your life, and I really can't tell you how to live your life. I really can't tell you what to do with your life. At the beginning of this video, I said you just do whatever you can do. What are the things that you can do is up to you. And I understand now why Ron Paul does not tell people what they can do, because if people follow your advice and they don't do it of their own accord, they have a tendency to come back and place blame on someone who told them that they should or could do a thing. The best thing that I have to offer people is to just get educated. Right now, we really need to get educated. We really need to see things for what they truly are. We need to take off those rose colored glasses and just get with the knowledge program. And I think that itself, knowing it and talking about it and having a majority of people understand what's going on will just sort of change things. There may be some things that we will have to do. We may have to do a little arguing and fighting and fussing, but that can come after knowledge. And some people already have the knowledge. They don't need to hear what I have to say. They already know this stuff. And for those people, they're probably all each fighting their own battles, but we really need to stand together as far as knowledge is. This is what I have to offer you, is knowledge and information, and hopefully a hope for a better future resting on the true foundations of freedom and liberty. So with that, please like, share, subscribe, and have a great evening.